Hi, and welcome back. My list of 7 deadly sins includes the bad moves I see Texas landlords make with their eviction notices. Often a landlord will hire me after having already attempted to send out a notice to vacate. These 7 deadly sins almost always result in my having to reissue the notice to vacate. In some cases, they'll result in substantial delays in the eviction process. The first deadly sin is being nice. This is when the landlord gives the tenant a longer notice period because the landlord wants to give the tenant plenty of time to move. Most landlords will tell me they just wanted to be nice about ending the lease. You can't control the timeline for the eviction process during the notice to vacate period, but you can control the timeline after you file the eviction lawsuit by requesting trial resets. Always use the shortest notice to vacate period you can. The second deadly sin is verbally notifying. There's nothing under Texas law that allows you to give the tenant a verbal notice. If you give notice verbally, you should expect the judge to dismiss your eviction lawsuit even if your tenant fails to appear. Always give your notice in writing. The third deadly sin is not naming every tenant on your notice. You'll need to look at your written lease agreement to see which individuals are listed as renters. If there are others living in the property, like children or other unauthorized adults, you just include the phrase, "and all other occupants," under the tenant's names on the tenant's address block. This step covers everybody. Your fourth deadly sin, not stating the waiting period. Your notice has to state whether it's a 3-day notice to vacate, a 10-day, a 30-day, or some other permitted waiting period. You should expect your judge to send you packing if your notice fails to state when the tenant needed to be out of the property. The fifth deadly sin is explaining too much. The only reason you need to state in your lease for why you're evicting is that your tenant breached the lease. That's it. Think about it. What happens if your tenant shows up to court with proof he corrected the specific issues you cited in your notice? Now you're on the defensive. Less is more when stating the issue on your notice to vacate. The sixth deadly sin is being unable to prove delivery. You need to be able to show your judge that your notice was actually delivered. Send your tenant 2 copies of your notice, one by certified mail, return receipt requested, the second by first-class mail. Use the post office's tracking system as your proof that your notice was delivered. Finally, the seventh deadly sin is not listing your certified mail number on your notice to vacate. It's great that you have proof that you sent the tenant something by certified mail, but how does the judge know that it was the notice to vacate that you sent to your tenant? Placing your 20-digit certified mail number under the notice to vacate's RE line is the best way for you to tie your notice to vacate to the post office's tracking system. I'd love it if you'd consider using my complimentary notice to vacate builder. Go to freetexasnoticetovacate.com. My free notice to vacate builder will print out a notice to vacate with the appropriate language and all of the information you need for court. That website again is freenoticetovacate.com. Thanks for watching.